1:15 by my watch, exactly 1:15 by the floor clock. Okay. Thanks for everybody coming back promptly. Hope you enjoyed lunch. Thank you very much, particularly to Denise and to Sue Wynn, who have been looking after us over lunchtime break.
Yeah.
Okay, one of the things that Alison has been training me to do was pronounce the name of our next speaker, which is Rosemary Auchmuty. Okay, let me just put my other glasses on. Well, you notice one of the earlier bits I was almost having to do this. So. Okay, Rosemary is Professor of Law at Reading University. She brings with her a surname of great interest to all one-namers, and hopefully she might say a little bit about it during this talk. However, as an author of a wide range of studies and publications about the law and how it impacts women, that's what she's actually going to tell us about for the main part of her talk. So I'll hand over to Rosemary. Thank you.
Well, thank you very much, Alan, and thanks particularly to Alison, who approached me. And it's lovely to be here and to see you all. It's a very interesting experience for me, coming from a different background. Yes, I'll say something about my name very briefly, but what I proposed to do was to say a little bit about where I come from, a little bit about how legal history is written and traditional legal histories and what's wrong with it. And of course, the main thing that's wrong with it is it doesn't say much about women. And then how we and I and many of my colleagues are tackling this now. There's an increasing vogue for doing women's legal history, feminist legal history, especially since the centenary of women's admission to the legal profession, which was in 1919. So the centenary was in 2019. And then I'm going to give an example of the work so that you can see the sort of stuff I do, which is the closest thing, I think, to what you do. Just where I'm coming from, basically, although I now teach law and have done for many years, I started life as a historian, and my first 2 degrees from the Australian National University, because I grew up in Australia, were in history. And after I came to London, I was on jury service and got interested in law, so I did a law degree, and that's how I got into finally getting a job in law schools. But since my PhD, which was in the 1970s, I've always worked on women and on feminist approaches to scholarship. And I think this is partly because my thesis was called Victorian Spinsters, so it fits really well with what Adele was talking about. I did write about the superfluous women, and particularly how there were well-to-do women who chose not to marry, actually, but who used that big army of unmarried women who probably would have loved to have married but couldn't, to push for women's entry into different sorts of professions and jobs. So it really fits nicely there. But since that, I've only ever done stuff on women. I think it's also because the 1970s were the era of the women's liberation movement. So I was writing about the first wave of feminism in the 19th century, and then I was part of the second wave. So that's the kind of work I've always done, and I've worked on property law. I teach property law and other things, but I've more recently got back to legal history because I think once you're a historian, it's always your first love, and it certainly is mine. As for the name, very briefly, as many I've spoken to have guessed, it's a Scottish name, but most of the Auchmutys left Scotland, went to Ireland at the time of Cromwell. They were Protestants, Church of Ireland though. The senior branch did have a farm, and there are still Auchmutys farming that, but the branch that my father came from, his father was a clergyman, they were poor, but I think probably regarded themselves as fairly well-to-do. My father, through many vicissitudes, ended up in Australia, and that's why I grew up in Australia. Both my parents are dead, so there are none left in Australia. There are none left in Scotland. There's a few in the north and south of Ireland, but I am the only Auchmuty in England. Lots in America, of course. So that's the name. It is very unusual. Okay, so on to my topic. As I said, I was going to start by talking about traditional legal history. Now, laws are really conservative discipline for all sorts of reasons. It's only recognises its own sources. It's been dominated by men, all those things. And so legal history is even worse. It's really very bad. Women are only included in traditional legal histories where you have to mention them, like Married Women's Property Acts in 1870, 1882, or when women got the vote. Well, obviously, you've got to mention that, or when they were admitted to the legal profession, or to mention women when it suits the tale of progress. Legal history's always been written as this tale of, well, it was terrible then, but you know, we're all equal now, aren't we? It's very much the old-fashioned Whig history. Things have just got better and better. And so, for example, I said I was a property lawyer. If you look at a trust textbook, it'll say the trust developed to ameliorate the position of married women. And they never, ever say, why did it need ameliorating? What was so bad about marriage? Well, I'm sure you know enough about what happened to women when they married legally in the 19th century to know that they gave up most of their rights. And so without any kind of finances of their own, because their property passed to their husband, we have the trust used to give women some money, married women, some money under trust. We are, of course, only talking about women from the classes that had some property. And what's left out, of course, are the lost battles, the feminist battles, battles by women who fought for a very long time to get married women's property rights, long before they got them, and all those other things, custody of their children, or the vote, or whatever. Left out also the backlash after the victory. So women have got something, great, we're all equal. Let's forget the story. And of course, as we all know, once you enter a profession, like the legal profession, which was male-dominated, it certainly wasn't the end of the story for women. It was the beginning of a very bad story of discrimination and exclusion. And the different effects of gender-neutral laws. You have these laws that purport to be the same, but operate very differently on men and women. And in these legal history accounts, reforms are always due to enhanced social consciousness, okay? Social attitudes changed. And no one says, yeah, but why did they change? Did they change perhaps because there were some movements to try and change them? Always because of enlightened and benevolent lawmakers. This lovely judge, Lord Denning, for example, who really liked women and did all these lovely things, okay? The increasing deservedness of the hitherto subordinate group. So women got the vote because they behaved so well in the First World War. We've all heard that story, right? Let's forget about the suffragettes and the suffragists. But never the agency of the group itself. So those campaigns are written out, and the reason why reform is needed is never because of oppression by the dominant group. So women get the vote, and the reason why they didn't have the vote before wasn't because men wanted to keep the vote for themselves, but just because, well, you know, it was different then. It was different then. Here's an example from Modern Legal History, a well-known textbook. Obviously, it's an old one now, but it was certainly around when I was a student. After the First World War and the dramatically changed role which women played during the course of that conflict, society began to take a radically different view of women's proper role in society. In 1919, the Law Society itself resolved that women might be admitted to the profession. So you see, it's the Law Society, the men, who are being benevolent and nice, and it's because social attitudes changed. Now let's see what actually is the case. So I'm going to focus on women as women in law rather than women and law, but I will mention women, but obviously I couldn't cover everything. So women in law. So in 1854, Barbara Lee Smith, well-known feminist from the first wave, published a brief summary of the most important laws concerning women. Now, she published this as part of the feminist movement, basically to show the world how the laws operated unjustly and oppressively on women. She didn't have a higher education. Women didn't go to university in those days, right? So, but she wasn't a lawyer, obviously. But she could do this because she studied it and produced it. In 1871, Maria Gray is refused entry to the Law Society exam. She wanted to become a solicitor. No, she can't. In 1875, we have our first woman law student, Janet Wood, at Cambridge. Okay, so they could go to university from this date on. They could study the law curriculum, couldn't take degrees, of course, not at Oxford and Cambridge until the 20th century. Eliza Orme set up a legal office in Chancery Lane. She employed some men, but the women did lots of the work. It was just the men obviously had to sign it off because they were solicitors and the women weren't, but they did lots of conveyancing, that sort of work. Okay? The small group for the promotion of legal education for women was formed. I just want you to see that date just to show that 1919, when women actually got admission, it wasn't because suddenly social attitudes changed. There had been a little bit of a campaign for many decades. And the first woman who graduated with an actual LLB, a law degree, was Eliza Orme, and she did the external degree at London. We've also got in 1903 3 women applying to the bar and being refused. Of course, you see Christabel Pankhurst was one of them. She did her law degree at Manchester, the first woman to do so. She got a first. Okay. Bills in Parliament. So there's lots of bills in Parliament to admit women, but they fail. There's the case called Beban Law Society, and I'm going to talk much more about Miss Bebb. She's my case study. But she challenged the Law Society, which had refused to allow her to study for the Law Society exams to become a solicitor. The committee to obtain the opening of the legal profession to women was formed. Ray Strachey, if you've ever read any feminist history, you'll know she wrote The Cause in 1928, the sort of first rather liberal history of the women's movement. And then we have finally in 1919, after the war, the Sex Disqualification Removal Act, which is the act which allowed the solicitors and barristers to admit women, or indeed force them to. Okay. So, how are women treated? What does this tell us then? Firstly, that they're ignored. So you get a history of the professions, for example, a history of the bar, or history of the Law Society. Women aren't mentioned till 1919, okay? Even though there'd been all that activity. There's no sense that those women, because they could not be lawyers, that they had any place in a history of the profession, and that's true of almost all professions. You might have women who are doing the work, as Eliza Orme was, but because she was not a member of the profession, she's just not in the history. It's never explained why they're not part of the story. Yet, we know they were doing law long before they could be lawyers. They campaigned to be lawyers. They had legal challenges in court and in Parliament. So, we need to ask why so many men were hostile to their admission, which in turn challenges the standard narrative of women being rewarded by a progressive, responsive establishment after proving themselves in the war. So this, I think, is what is so important for us doing this history today. It's not about saying, well, women did this, 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 and this, here's the account. It's actually saying, yeah, but why did it take so long? What was the attitude? Where were the men in all of this? And that you also don't get in the traditional histories. There's nothing about men's opposition. So after admission, the other thing I said was, we all know that when you enter a male-dominated profession, or a white-dominated profession for black people, it's the same idea. It's not the end of the story. There's not going to be immediate acceptance. It's not going to be equality after that. But these books present it as though that's the end of the story. Right? We can now move on and talk about lawyers and forget about the different experiences. So what's happening after admission? First of all, we get our first women solicitors, barristers, magistrates, and jurors. Women can vote, they can stand for Parliament. And then in 1925, we have the first woman professor of law in Ireland. I put her in because she is so remarkable, Frances Moran, when you look at the dates in England. Okay? So, 1965, we're waiting now 45 years before we have our first High Court judge. Our first woman professor, we're waiting another 45 years from the first professor of law in Ireland. Okay, and that actually was in Northern Ireland she was initially, and then she went to Kent, Clare Pally. I wanted you to draw your attention to Women in the Law, this wonderful textbook written by Sue Atkins and Brenda Hoggett. Brenda Hoggett is, of course, Brenda Hale, Lady Hale, but she was an academic and that was her name at the time. Her husband's name, I think. She then dropped it when she divorced him. And it's a wonderful book because it's very much imbued with second wave feminism, and it really does set out the disadvantages of women in the law at the time. And it wasn't replicated by anything really until it's not actually been equalled since. And we don't have textbooks of this sort in the university today. Then we've got 88 for the first woman in the Court of Appeal, 2004 for the first woman in the Judicial House of Lords, which is Brenda Hale, and the first woman president of the Supreme Court, only 5 years ago. Okay, so, and they talk about how that, you know, that the resistance has been fabulous. You'll have followed it in the papers about, you know, we appoint on merit and so on. So, you know, we have waited a very long time and there's still not equality in the legal profession. Even though actually 70% of our students, law students, are women. We teach a largely female contingent. So, how is this presented in the history? They're subsumed into the general experience of lawyers. That is the experience of men. They're just forgotten about. It's just you don't have to put them in. Because if you did say, well, actually men did this and it was very successful, but actually lots of women couldn't make a living in the bar because they weren't given any work, they faced terrible discrimination, had to set up their own offices or their own chambers or whatever, right? That would expose the fact that the experiences of men and women are different, and that the relationship between the men and women was often hostile and discriminatory. There were a lot of lawyers who did not like having the competition from the women. So we need to look at women's lives, but also, and this was so novel, I think, for many of us, in biographies of men to consider their role in the gendered relationship with the women. And I went to a workshop in Germany which was on legal biography, where a lot of German scholars were talking about this great man and that great man and so on. And I realized in the end that their whole notion of biography was totally different from mine. And they thought mine was just absurd. All they cared about was that man's contribution to the development of legal doctrine. So there was nothing even about their wife and children. Whereas I think the most important thing to look at, of course you want to do that, but to get an understanding of the legal milieu, what you've got to look at is, well, how did they treat their wives and their children and their daughters? What was their attitude to women's rights? What role did they play in voting for, voting against, promoting, and so on? Because that will tell you so much about them. But very few biographies of legal men look at that kind of detail of their private lives. They'll say who their mother was and what children they had in their wife. Nothing about how much the wife helped them in their career or how she subordinated her life to theirs. So this is why I think that feminist legal history isn't just about putting women in, it's looking again at those men. So what do we do? On to how we challenge it. Okay, first of all, we ask the woman question, which is the standard women's history. Okay, first you look for the women, you try and find the women, which is what we've been talking about today. You put women back into that account, even before they were admitted to the legal profession. Secondly, you foreground gender as an organising principle in society. So just as you would look, say, at class, as we have done, and you'd look at race, you look at gender in the sense of men and women. I mean sex, but you can't say sex because it sounds like something else. So gender as that relationship between men and women, the dynamic between the sexes. You also look at how law impacts differently on different groups, okay? So it could have a much stronger or more unfair impact on women, particularly in the legal process, this is the case. Because often you'll see, if you look at judgments, and this is something actually that first wave feminists used to do, they used to publish the sentences that were given to male criminals and female criminals. And the male criminal could have beaten his wife to death and get 10 years or something or less, but the woman who had stolen 10 pounds would get life and penal. Really, really dreadful, egregious, right up into the 20th century, differential sentencing. This whole idea that if a woman does something wrong, she's really evil. Whereas, of course, and it is true, it's quite normal for criminals to be men. We focus on women's stories and women's agency, okay? Don't just look at the laws that were passed. Look at how much it was that women were doing to get these laws into Parliament, to get these cases heard in the courts. We don't talk about social attitudes changed and suddenly Parliament gave women the vote. We talk about the fight that women had to get whatever it was. We don't just look at how institutions suddenly became liberal, okay? And we explore men's agency, whether in promoting or maintaining discriminatory laws or in enabling reform. I mean, it's really interesting to look at the men who did support women, because, after all, none of these reforms would have happened at the period I'm talking about if they hadn't had men on side, because they weren't in Parliament, they weren't in the courts, they weren't lawyers. And so they did have half a dozen men, maybe, in Parliament who would introduce the bills, and others who would be persuaded. And the same, they had some powerful judges on their side. Although often the support was kind of, it was for some issues and not for others. So you might have a lot of men who are in favour of higher education for women. They're quite happy to have women get law degrees, bit less happy about having them actually become lawyers or have the vote. So that's also very interesting to look at. We have to recognise that legal landmarks are rarely the end of the story. There's almost always a backlash, regrouping by opponents and new obstacles to face. Now, one of the projects that was undertaken as a result of the 1919, the centenary of the admission of women, was one that I did with Erica Rackley, and we got together 100 scholars and we put together a book called Women's Legal Landmarks, which looked at landmarks in the UK and Ireland from actually over 1,000 years, but basically people offered their own. It's not comprehensive. People offered their own landmark, and they were all put in the similar sort of format, which showed the context, the landmark itself, what happened next, always very important, and the significance of each landmark. And that demonstrated, above all, you couldn't have seen it more clearly, that whenever you get some kind of reform, for example, the rape laws are changed so that you can't give testimony about the victim's private life, but somehow the courts all get round it, yeah? And we show how that happened. And that's always the case. And that then challenges the traditional presentation of women's linear progress from oppression to equal opportunity. There's very much this idea, and you get it right through history. Whenever women get something, they're then told they're equal. So in the interwar period, for example, women really struggled to get any kinds of reforms through because they're told, well, you're equal now. You know, you've got the vote. You can work. Well, of course, they weren't equal. And this method doesn't simply add women in. It produces a whole new story. It's not just traditional legal history plus women. It's a totally different story. So just a little thing about biography, because we also in the Women's Legal Landmarks had some biographies of first women, because they were landmarks, if you like. And there were other projects, not just ours, that went on at the time. And one of the things that was really, we noticed, was that there is very much a tradition, which was kind of around in whatever existed when I was young, about women who'd ever done anything. Grace Darling, I think, was one. Florence Nightingale was also one. They were always set up as heroines, okay? And Hilary Mantel had this great thing. You see, she said, when we memorialise the dead, we're sometimes desperate for the truth and sometimes for a comforting illusion. Well, I think this sort of setting up all these women as heroines is very dangerous because, first of all, it makes it look easy, but also it makes it look as though we could follow. And you also get this with the Taylor progress, the role model. How many accounts I've read where the woman is presented as a role model for aspiring women lawyers or law students. And when I think about this woman they're talking about and my law students, I realise that nothing they could do is similar to what that woman had. Very often those first women who had senior positions in the law came from legal families, right? They were upper middle class. They were obviously white. You know, they had all the advantages, you know, the disadvantage, of course, of being a woman. But, you know, if you're going to have a woman, to have one like my daughter or my wife or, you know, is what I would like as a legal man. And I look at my students who are black, who wear headscarves, who are working class, who are the first generation to go to university. And I think, and who aren't, it has to be said, at Oxford or Cambridge, right? And I say, you know, this is not a model for you. The obstacles you face are going to be very different You're going to have all the ones that she faced and all these other ones. So I don't like role models, and you don't see this anymore for men, but you used to see it, of course, for boys, you know. I don't like the misplaced familiarity. Now, I quite understand why you use first names all the time, because you've only got one surname you're dealing with. So, of course, everyone has to have a first name. But these accounts, these historical accounts where you're talking about, you know, all the men by their surnames and all the women by their first names, there's two problems with that. One is it infantilizes them, you know, little girls, you know, known by their first names. Secondly, it suggests you get on very close terms to this. You know, I've seen researchers who identify so closely with the person they're researching that they're making up their own minds about what she would have thought or would have done, which isn't on the evidence there, because that's what they would have thought or would have done. It's very, very dangerous. And this all came out of this really laudable exercise of all of us looking into women in the past, but doing it in this way that I think was full of pitfalls, and illuminating the present the same. Often it doesn't illuminate the present at all. It tells you about the time, and it tells you that there's going to be opposition, and that's about it. Okay, so the real question is not what did she achieve? You know, okay, she was the first or not the first. And why do we leave out the ones who weren't the first? They're often the ones who failed are actually the interesting ones. We should be looking at how did she get from there to here? You know, how did she get from this background to this position? And we need to think about whether we could. And to answer that question, we need the facts and the primary accounts, okay, but also the context. And that, I think, is why I think, again, Adele's talk was so interesting, because it's fine to find out all the facts, and that's very, but unless you actually see, well, she was a whatever she was, a job, and this was typical because this is the condition she worked in, and this is what other women were doing, and her reaction is actually quite similar to that, it's not going to make much sense. Now, the facts, I just want to say just a couple of words because I want to race on and get on to Miss Bebb, and I see that time is passing. But the facts aren't easy, and I don't need to tell you that. The one I actually want to highlight is the second one there, the facts that aren't facts at all. When I started researching Miss Bebb, I went online. We all do, right? Same story is told, and all, you know, same anecdotes are told on all the sites. Well, you think, well, they're on all the sites, so they must be true. Well, of course, they've all copied this wrong anecdote from the same source. And that's a real issue for us, I think. And the other one, of course, is the private facts. We've got to remember those, for the men especially. And then Hilary Mantel again saying, evidence is always partial. You know, we can't be sure. Facts are not the truth. Okay, so the context, just a little bit here. And I'll just draw your attention to the quote at the end there, which was a review of a book by a lawyer in the Guardian Review. And he said, the interviews, statements, documentary extracts, anecdotes and reflections that make up the book are often fascinating. But X, I didn't want to put his name in, he's quite famous, hasn't done enough to give his narrative coherence. To the historian, it looks like a first draft. And that is a problem for lawyers, that they don't actually know how to do history, you know, and they think it's enough just to have a few facts. And the other thing about history being a dialogue between past and present, we need to understand where we're coming from, why we're asking those questions and not others. Are we being anachronistic? And again, of men I've mentioned there. Right. Always interrogate an example that says, I've never experienced any discrimination in my career. Always look at she was able to succeed because her husband helped with the housework and the children. I mean, what does that tell you? He helped. Yeah? Right. Okay. Of any life. On we go. Anyway, Miss Bebb. I want to talk about Miss Bebb. Now, Miss Bebb, as I said, challenged the Law Society in 1912, actually, the first case, but it was reported in 1914, because she wanted to enter the solicitor's profession. And she was a test case, so there were others who could have gone forward, and it was part of that campaign that I talked about. And my aim in looking at what happened to her was to find out what happened to her, because there she was. In some history books, you would read about Bebb and the Law Society, and her case is certainly reported. You can read the case. But there's nothing about who she was or what she was before. And crucially, there was nothing about her afterwards. And you would have expected to find her if she'd qualified on the solicitor's roll or on the Inns of Court records or something like that, and she wasn't there. And so I asked the question. The article is actually called Whatever Happened to Miss Bebb. So few facts I found, which are the same as you would have found looking at the relevant sources, birth certificates and so on. She was born in Oxford. Her father went to be principal of St David's College in Lampeter. She was sent briefly to school in Paddington. It was a boarding school for clergymen's daughters, sort of. And she passed matriculation and went up to St Hugh's. At Oxford, she was only the 7th woman law student at Oxford, because even though they'd been going there since the 80s, because they couldn't become lawyers, they sort of declined to a trickle of entrants. She was the only woman out of almost 400 law students, and the only law student in her college. BA Jurisprudence is what the degree is called at Oxford. There's a little bit about what she studied. I mean, she was particularly lucky, unlike someone, for example, a woman who was studying English, who would have been taught by women tutors, who would have been fine, no doubt, but who were not the examiners. Whereas she, because she was one, and had to be chaperoned, of course, she was taught by all the men, and these are great names in jurisprudence, okay? She was taught by them, and she was taught by the examiners, so she knew what was going to be in the exam. Well, not exactly, but you understand, it's very different. She had a very good experience. St Hugh's was interesting. She didn't leave any records about this, but if you're dealing with someone who went to Oxford or Cambridge at this period, there are lots of memoirs, biographies, and so on. There are institutional histories. She wasn't in the first one of those. She is now, since I did this. It's really nice to recreate her life, and I spent some pages recreating what it was like for women in a women's college at the time. How the other girls were mostly her social level. The others would have gone to Somerville or Lady Margaret Hall, which were more expensive. They had small bed sitters, not separate sitting rooms. How the timetable was organised. They certainly had chaperones, they had curfews, but so much freedom compared with their life at home, where women, unmarried daughters, were meant to be at the beck and call of their parents, really, their mother in particular. And the intellectual rewards, not just from the male professors, but from the other students, because they're mixing with really very bright young women. So she graduated with first-class honours, okay, joint top of the class, couldn't get a degree, don't forget. And she went to work as an investigating officer in the Board of Trade. Now, what's so interesting about this is she was prosecuting people who were in breach of the regulations, but she wasn't a lawyer. So she's doing their work, although she's not qualified. We have at the same time the campaign going on with all these bills before Parliament and her application, and then the case. Now, the case was heard on the grounds that the Solicitors Act 1843 said in section 48, every word importing the masculine gender only shall extend and be applied to a female as well as a male, unless it be otherwise specially provided, or there be something in the subject or context repugnant to such construction. Okay? So they're saying this says in the Solicitors Act that male means female too, as actually in most legislation it does. However, her case went first to the High Court and then to the Court of Appeal. Here are some extracts from the Court of Appeal. Judgment in the words of the Master of the Rolls, he's the head of the Court of Appeal, said, first, there's been that long, uniform and uninterrupted age which is the foundation of the greater part of the common law of this country, and which we ought, beyond all doubt, to be loath to depart from. In other words, there have never been any women solicitors, so there can't be. Okay? The Act of 1843 confers no fresh and independent right because it doesn't destroy a pre-existing disability, right? Women were disabled from. And finally, our duty is to consider, and as far as we can, to ascertain what the law is. We only look at what the law is. We don't make law. I disclaim absolutely any right to legislate. That is for Parliament. Those three arguments, the first which follows the doctrine of precedent, you've got to follow what went before. The second one which says that the statute doesn't introduce anything new if it contradicts something that existed. And the third which says, oh, the courts don't do this, right? We see that throughout women's legal history. It's very, very common, right up to the present day. Because that keeps the law the way it is, and it's only when courts depart from that, or the legislature intervenes, that the law changes. As, for example, in the case R&R in 1991, which said, well, actually, there is such a thing as rape in marriage. Now, the court was able to say this on the basis of a law which, for centuries before, they'd said, we can't say this. So you see, it's only when they actually make an effort to change the law that it will change, and that takes the will of the courts. So what happens to Miss Bebb? Okay, we see that the campaign continues during the war. She works first for National Service for Women and then as an enforcement commissioner in the Ministry of Food, again prosecuting people who made violations in the food rules. She got an OBE for that. And then she got married. Well, immediately you know now why, one reason why she disappeared. She married a solicitor, went to live in Tewkesbury, and there she is. I thought you'd like a picture. Yeah. This was supplied to me by her granddaughter. Okay. In 23 December 1919, her daughter was born. Okay. On the 24th of December, the Act was passed, admitting women. And in the same month, she entered Lincoln's Inn. So she's decided she doesn't want to be a solicitor. She wants to be a barrister. And her husband, of course, was a solicitor, and she'd earlier argued to be a solicitor, but she wants to be a barrister. So there she is with this, like, 2-week-old baby, and it's not standing in her way. She also, in 1920, was able to graduate because the other thing the Act did was allow the universities to admit women to degrees, and Oxford agreed and Cambridge didn't. So Cambridge didn't give women degrees till 1948. But she was able to graduate with a BA, which, if you know Oxford, means an MA eventually. And she was chosen to propose the toast to the bar at the banquet for the Committee for the Admission of Women to the Legal Profession, which they had this big celebration where everyone was there, you know, the top judges and everyone, and of course all the people who'd been involved in the campaign. So what happened to Miss Bebb? Well, she had a second daughter in 1921, her daughter died, and then she died. And this we found on her death certificate. And it's all written in just like this. She died of placenta previa, which many of the women here might know what it is. And this is all written on it, literally. Ante and postpartum hemorrhage 2 months ago, thrombosis of pelvic veins, cardiac failure 2 months ago, and presumably cardiac arrest in the end, right? So she died. She died. And that's why we don't see her becoming a barrister. And being, in fact, it was thought she would be the first barrister. It was in all the papers. What's interesting about this death certificate? Occupation column, wife of Thomas Weldon Thompson solicitor, and marginal note in the same registrar's handwriting. Mrs. Thompson's description should have been thus: OBE, M.A. Oxon, barrister at law, manager of bank at Sherford House, that was her husband's practice, etc. Now, she wasn't actually a barrister at law, but I see why they put that in. There you are. So some feminist voice, possibly her cousin who actually reported the death, a woman cousin, put that in. But isn't that brilliant? Isn't that wonderful? So why was she forgotten? First, because she married, and of course Thompson, not an uncommon name. She died at 31 before admission to the bar, but mainly because of these conventions of institutional histories. They do not care who the litigant is. It's just the case that matters. Women are ignored, or they make cameo appearances. They have to show that legal development is a tale of progress. Okay? Well, she did try and get in, and then a few years later, of course, social attitudes changed. And women's agency is denied. The fact that she was part of a major campaign to change it is just ignored. Now, I've got 2 slides now to finish with on her wider significance, because one of the things for us working as academics is that we can do our own personal research and it fascinates us. But the way to make it valued by the institutions, but also more valuable actually to the scholarly world, is to make those generalizations that widen it out to other women. Not all women, and I'm not saying, you know, they all behave this way, but actually to make these points so that she's just one of an example of the way in which women have experienced history. First, it represents women's public struggle. She's the only name that's associated with women's entry into the legal professions. You know, all you ever learn is this case name, Bebb and the Law Society. And one of my male students once said to me, well, women can't have cared very much if they only started complaining in this case, you know, because that's the only thing on the public record. But it also represents women's private struggle, and that's where you can generalize out, trying to combine work and family. And particularly at a time like that, just very briefly, it was actually more dangerous to give birth as a middle-class woman than a working-class woman, okay? Because the middle-class women went into private hospitals or nursing homes where there wasn't proper medical care. But a lot of working-class women by then went into hospitals where there were honorary medical, proper doctors who would treat the private patients, but also would do pro bono, would also treat the working class. So the mortality rate was higher in the middle class institutions and amongst the middle class people living in West London, say, than in East London. And so that's really interesting, it seems to me. But anyway, so she's trying to combine work with family, and for this reason it shows that women's lives will be different from men's. And it's wrong to say, okay, they become lawyers, it's all the same from then on. I mean, you don't have to die in childbirth to prove that, goodness knows. Simply the different kinds of expectations of women would do that. So I think for Miss Bebb was not just a symbol of change, Bebb and Law Society. She helped to bring about that change, and we need to acknowledge that as part of a long, coherent, interconnected feminist campaign lasting over 50 years. And her story reminds us that women usually have to fight for their rights, that men will usually defend their privileges, and that reason and justice may be irrelevant in the face of institutional power. That's it. Thank you.
Wow, thanks, Rosemary. Some really thought-provoking stuff there. And even just sitting there, I'm sort of thinking back about some of the, I mean, I haven't got anybody of that ilk that went into the law or anything, but just still thinking about, Victorian times, early Edwardian times, how the women were struggling and how they were part of getting a better life as industrialisation happened and all of that sort of thing. And there's a little bit in some of the stories I put on there, a little bit alluding to that. But I'm sure, hopefully, that sort of generated some questions from the floor. Or you're all stunned into silence.
I was just thinking back on my own life, because I studied law about 1968, and I had no idea that there may not be a pathway through on that, and that it was dominated so much by men. Luckily, I changed profession, so I didn't have to put up with any of that. But I also think that there are institutions today that still practice that. And I never really did see discrimination early on in my career. I get more of it now, which I don't understand.
I'm wondering if you were taught by any women or how many other women there were in your classes.
I didn't. I studied myself and went to the exams. I didn't go to an institution.
Okay. Yeah, which is another thing that women do. Yeah. No, that's true, actually. Certainly our students find it hard to accept that there'll be any discrimination when they are in the majority and are treated as equal. But at each stage as they go up, it funnels off opportunities. Do you know law is the biggest undergraduate, has been for about 10 years, biggest undergraduate course. And we have hundreds and hundreds and hundreds, thousands of students every year coming in, but hundreds in each institution. And there aren't those jobs at all. And they think they're going to get work, especially if they're new to higher education. And it's just going to be a terrible struggle for them. Yeah.
Working from home is going to change things, because it's much more difficult to be in contact with your colleagues and to organise any sort of protest if you think that you're being discriminated against. Do you think that working from home is actually going to make things worse again?
That's a really interesting question. I thought you were going to ask how it affected working women, because I think there's heaps of research to show that it's held women back because they've been largely responsible for, certainly during lockdown, for more domestic work, and particularly homeschooling, of course, during lockdown, even as it made it more possible for them to be online participants in, say, international conferences and things like that. So they could get together that way, but in a different way. 3 weeks ago, I ran an event with a colleague in Paris, and we actually said we're not going to do anything online. And we're not actually allowing any PowerPoint slides either. And we had people from every continent come, and they had to come in person. And there was this huge appetite for getting together and talking to people, and it's at those sorts of events that you network and you meet people who are working in the same field and so on. So I think that we're going back to not working from home in many professions, that there's going to be this appetite for at least part of the week, but possibly, certainly at my university, we're now totally offline. Everything. Last year we did our lectures online, but this year we're going to be in place. So I don't know. I mean, I think the fact that people can join and can get recordings and so on is helpful, but I think we're always going to want to get together, I think. I don't know.
I actually work as a legal secretary. And I have gone back into the office full time, partly because I live on my own and having my office at the corner of the living room is driving me bonkers. But also because of the lack of contact. I can remember sitting at home talking to one of the other secretaries from a different office, and there was a small child carrying on in the background, and she kept having to sort of not exactly put me on hold, but sort of shoot the child out and tell her to go and harass somebody else. But you're right about the need to be in the same place as your colleagues, because without that there is so much less toing and froing. I mean, our office is a branch office, and we generally have like 1 or 2 representatives of each area of the law. So we're much more sort of, the office is a team rather than our head office, which is very sort of departmentalised, very siloed. And you know, there's more sort of interaction between the different legal disciplines. And I think, I mean, for some people working at home is lovely, but like you say, for women, there's all these extra pressures. I mean, yeah, it's fine. Oh, I can do the laundry while I'm on a phone call, but
it doesn't work that way, does it? No, what they found in law schools was that the men did much more research and got all the kudos and the promotion and so on with that. Women couldn't do their research at all because they've got the kids around all the time. So yeah, no, exactly. I think you're right. I think, though, there's one other thing you might say, because I make it sound like the women's movement was really all together, and of course anyone who's been part of any organisation knows that there were factions and disagreements. And we've discovered that if we have meetings online, people are much ruder to each other, much less pleasant than we would be if we were all meeting like this. And I think that's another reason why we want to get back together as far as we can.
And also, not trivialising what we're saying.
Yeah.
The fact that we want to come together in a face-to-face seminar, for a lot of people we are zoomed out.
Yeah.
And you don't get that interaction, both from a discussion like this, but also just, over your coffee breaks, your lunch breaks. One of the things we've always thought about seminars, when they're in person, sometimes you can get as much, well, not belittling the speakers, but you get a lot out of the sessions outside of the
Oh, yeah.
sessions.
It's the most important part, I think, actually, the socialising and the networking. Yeah.
It's interesting we've got onto this because there's a quick plug here for my favourite family history book, which is Round About £1 a Week by Maud Pember-Reeves, an investigation into the lives of respectable working class women in about 1909 to 1912. And one thing that they mentioned in that was how lonely these women were, because they had to be in their houses with perhaps a baby and just not baby anymore, toddler, and everybody else was out at work or school, and they had no one to talk to, and they had nothing, no stimulation.
Yep, and that's been repeated with generation after generation. The National Housewives Register was set up for middle-class women who were stuck at home with babies, who'd had, educated women who'd had jobs and were just going mad. When I first started teaching women's studies for the extramural department at London University, one of the things they hated was having to write housewife on the census. They hated having, or on any form at all that asked for their occupation. And I don't know if that's true of all of us, that really felt like it's not just an occupation, it's actually saying I'm no one, I'm nothing. Yeah.
I often wonder if our organisation isn't the same, because how many vice presidents have we got who are female? How many chairmen have we had who are female? Very few. And looking at the audience today, there are more women than there are men.
That's a good point, actually. Normally your meetings would have more men, is that right? No? Well, there you are. What a good thing to say.
I feel marginalised.
Yeah. Well, I think it's good for men to feel that way. It's so unusual.
This wasn't what I would say, but actually I think you find it's a more female-orientated hobby. What I was about to say is I quite agree with you about the fact that lawyers cannot write history books. I read a book called Pettifoggers and Vipers of the Commonwealth about law in the 16th century, and it has to be the book that's put me to sleep more times than anyone else.
Well, I'm with you on that, yeah.
Just to hopefully close off the chat we're having about working at home and all the rest of it. I know we're talking modern day. I've got 2 points. I spent a lot of my career working for Siemens, 450,000 employees who now all do hybrid working, i.e. Siemens might have 100,000 desks for 450,000 people, so you phone up, have your desk, arrange a meeting, and most you work from home. That's in now, and then the offices have gone. So that's going to be forever. So, but that's engineering, and so I've been in engineering. When you look at women in work coming through, in the 80s and 90s when I first started, because I'm only 23. So there was a push. It was the Duke of Kent who was president of something, or vice something on BICC, who owned the company I was working at the time, and he was all for women in engineering, because obviously it was a male-dominated environment. And at that point there were two in 100 of us. One happened to my previous wife, no disrespect here, was an engineer, but both of them were software engineers. And what I discovered is that in the 2000 onwards, I was running an engineering team, which was a software team, of which there were 50 employees. And of those, there were 5 direct reports to me, 3 blokes, 2 women, and across the block, it was a good 50-50. So as software in engineering has become bigger and bigger, the female content, if that's the right word, of the workforce has probably even. And it's probably the same in universities. Obviously, I was studying in the 70s, so I don't really know. That was a course of 100 at Upper University, and only one female on it. But now I know it's changed, and so it's mainly in my industry, software, that's changed that, because I suppose it's seen as a softer work at the desk rather than climbing poles or digging holes. But yes, it's just you talking made me think of my personal experience.
But there's 2 different things there. There's software engineering and there's engineering software.
Yes.
Which were you talking about? Both?
Probably both, yes.
Yeah.
Yes.
I think there's a danger in equating working from home in the pandemic to longer ago, and it doesn't really reflect working at home as it can be. Usually the kids aren't there. Usually there are other social events you can go to. There are networking events. There are hubs that you can go to if you want time in an office. It doesn't necessarily have to be an office. And I think the two have got conflated, and people are very anti-working from home now because they need that social contact. But actually, having worked from home for the best part of 20 years, it isn't normally like that. So I think you have to be a bit wary about generalising from the pandemic into normal working at home when there is social activity going on and you're not trying to homeschool and do the housework and everything else at the same time.
Yeah, no, of course you're right, although I think it's probably true that women still do most housework and childcare still. But perhaps that's changing, I hope so.
Okay, John.
Thank you. I was a personnel manager in the 1970s, and we had the Sex Discrimination Act come in. As a result of that, I set up a group to job evaluate everybody in the factory. But I lost that job because we ended up with some women being allocated skilled status, and that caused no end of troubles. The works manager gave me the sack from my job because that's not what they wanted. Exactly. Put the wages up, but it did enable some new machinery to be introduced, which bypassed this job.
Which is exactly exemplifies what I said. There's always going to be a backlash. So you, as the woman who's achieved this skilled status, so then you lose your job because a machine takes over.
Yeah, that was to do with electronics.
Yeah. I know about that job re-evaluation because, of course, what that meant was that jobs were all re-evaluated, so that there were men's jobs and women's jobs, and there wasn't equal. They didn't have equal pay for work of equal value, which came in subsequently. When they really did say, well, this job, and there's a lot of case law on this job as a cook is actually equivalent to this job as a welder. I think it was in the case. So, yeah.
We had to compare that sort of job.
Yeah. Well, good for you. You were doing the right thing. But sorry you lost your job.
But in Aberdeenshire, they're struggling to get women up to the men's wages levels now.
Yeah.
And they're going on strike. Workers in Aberdeenshire.
Yeah.
They're 50 years behind.
Yep, well, yeah.
One last question.
Thank you, Rosemary. Very interesting talk. I was particularly struck by your comment about the period after which the legislation was passed and how long it took for, shall I generally call it, society to actually absorb the change. You can see parallels, can't you, in the gay community, in the racial communities of various sorts, other so-called minority groups. Do you have a sense in this of how long real change takes place? I mean, obviously it's continuous, but do you think women in law are a better place now after, what would you say, what are we talking about?
50 years, yeah.
100 years, aren't we talking
It is
about?
100 years, yes. Well, I think it's not so much that society didn't catch up. I think it's that the legal profession didn't catch up and that they had the power to exclude women from the higher echelons. I mean, they held all the tricks, really. And I think that's possibly the case with, I'm just trying to think about sexuality. By the time the law changed, we've got 1967 for gay male sex, and then moving on, to civil partnerships in 2004, and same-sex marriage in 2013. I think by the time they were passed, they were non-controversial. So society had got there earlier. It was more the lawmakers that hadn't, and the powerful interests, so the church interests or whatever it might be that opposed it. I don't know if we can generalise. I mean, you all do history. I'm not sure we can generalise at all. All that I would generalise is there's always a reaction from those in power. People in power don't like to share power. The people who do are extraordinary, and they're amongst us, I'm sure, and that's how things do change eventually. But But it's often such a compromise. I mean, so often these reforms are such a compromise. Same-sex marriage, for example, is not the same as opposite-sex marriage. You know, the actual provisions are not the same. But as long as the public doesn't know that, it doesn't matter, does it? You know? So it is all about this compromise, not quite what we wanted, but better than what we had before. And then you get Roe v. Wade in the US, you know. That's a classic example. That you win something and it's been there 50 years and you think they can't attack that. And they do. So I don't think you can predict anything. It goes... Yeah.
Thank you very, very much, Rosemary. So just like... So just a quick 5-minute comfort break and then we're back with the next session.